Gentleman yields back. Who seeks recognition? The gentleman from Georgia is recognized for 5 minutes.
Thank you, Mr. Chairman. Professor Richards, I mentioned in my opening statement my concern that broad federal preemption of state AI laws would also preempt common law causes of action. How does common law, particularly tort law, help protect Americans from harm?
Well, thank you for the question, Representative Johnson. Common law is the foundation of American law. It is older than the United States. It goes back to the colonies, to the English tradition. Common law has a flexibility to the law. If we think about my own specialty, privacy law, there was a reference earlier by one of the other witnesses to Justice Brandeis's right to be let alone. Privacy law in America, it was originally a product of common law, where the law adjusted to realize that data about people, information was being collected without their willingness, it was being disclosed. And an important line of cases relevant to this subject today, to protect the names or likenesses of people whose pictures and names were being used to sell products without their consent. So common law is a tremendous source of flexibility and vitality in our law that allows the law to adjust to change circumstances like the advent of technological revolutions such as artificial intelligence.
Thank you. Can common law be used to protect Americans even in the absence of explicit statutes?
Absolutely, sir. I mean, that is sort of the nature of the common law, that judges can apply the existing rooted principles of tort law and contract law and property law, and they can, from those general principles, divine specific applications that can provide new protections so that the law continues, as it always has, to evolve alongside technological invention, as the ranking member referred to Mr. Jefferson's statement from 1816, which, as a proud graduate of UVA, I also endorse.
Some of the current lawsuits against AI companies are being brought under common law to hold companies accountable for the harm that their products have caused to children. For example, Megan Garcia is suing Character Technologies and Google after her 14-year-old son, Sewell Setzer, died by suicide. She testified before our colleagues in the Senate this week that his death was, quote, the result of prolonged abuse by AI chatbots, was the result of prolonged abuse by AI chatbots on a platform called Character AI, end quote. The chatbot sent Sewell sexual messages and asked him to come home to me as soon as possible. Others have filed lawsuits against Character Technologies and OpenAI for wrongful death, negligence, and other causes under both common law and state laws about deceptive or unfair trade practices. These tragic cases show some of the worst possible harms that can arise from AI technologies. Professor Richards, does an AI moratorium run the risk of impeding these lawsuits that seek to hold companies accountable?
It would, I particularly if it were defined broadly. And let me also say in response to your question, Representative Johnson, as a parent myself, my heart goes out to the families who've lost their children. I think when we think about laws like negligence or rules like negligence, negligence was the great innovation of the common law to respond to industrialization. It means that anybody acting against other people must behave in a reasonable way and not cause unreasonable harm. I am sure that the car companies and the railway companies and the industrial companies of the 19th and 20th centuries would have argued that the common law developing the law of negligence would have impeded innovation, but actually it safeguarded the development of those technologies by enabling us to be able to drive cars and ride on the rails and fly in airplanes and otherwise enjoy the benefits of our inventions, knowing that we are safe and we are protected. And where those technologies or their deployers overstep the line, we have a right of action to defend our rights and protect our families.
Thank you. And it was states that developed the common law. Professor Richards, beyond common law, are there some areas where it's appropriate for states to lead the way on laws about AI technologies And if so, what sectors or use cases should continue to be the providence of the states?
I think the answer to that question is yes, and I think particularly where there is deployment of AI rather than generation of AI, the use of AI in point-of-sale devices, employment discrimination, consumer protection, the traditional provinces of state regulation. And let me also, if I could add one additional thing, Representative.
Briefly.
States have filled the gap that this Congress, which did not regulate the internet, did not regulate privacy generally, have done so. And I think with AI technologies, if Congress is for whatever reason not able to pass comprehensive legislation protecting Americans, states will continue to fill that gap as they have in the internet age.
Thank you. We now go to the gentleman from Texas, Mr. Gooden, for